Well, ladies and gentlemen, those are really interesting top crime stories. That mistrial with regards to the alleged rape is certainly a case that we're going to keep our eyes on. So many women who are now more careful when they go out running by themselves because of cases like that one. So be sure to stay tuned with Law&Crime, because we will be continuing to follow up on that case and others, unfortunately, like it. Today's case is a little bit of a different one here for Law&Crime. So many times we, the viewers at least, get really excited and very much want justice against the defendant. But in this particular case, I know many of us were feeling for the defendant in the case. That defendant, Daniel Villegas, had been accused of the murder of two individuals, had tried that case and had a mistrial, had a retrial and was convicted, and spent 18 years behind bars before his case was overturned and he was sent back for yet another trial. That is the trial that we're going to be playing for you this afternoon. But before we go to pieces of that case, I want to talk to my guest for a minute. My first guest is David Pietro. He's a trial attorney, has been here with us before. Good afternoon, David.
Nice seeing you again. How are you?
I'm doing well, and I'm really excited to cover this case. You know, I was walking in here today, I was thinking of what a Thanksgiving Villegas is going to have, given what he's been through in the past year. Before we start playing some of the testimony, let's do a little bit of a recap here for our audience. This is a case where this man had been accused of the murder of two individuals, Bobby England and Armando Lazo. And his allegations against him were based in large part on his confession. How much of the case, David, do you think was really based upon the confession that he allegedly gave?
I think apparently a lot, because on the retrial, when the confession was thrown out by the appellate court, they offered him an outfit, which basically allows him to plead to plead for time served but maintain his innocence. And he turned that down in the face of a life sentence, which is really remarkable, because most people, even innocent people, after spending 18 years in prison, would take an Alford plea just to get out because they know it's over. So
yeah, I mean, let's break that down a little bit. The prosecution offered him to walk away free, no trial, no risk of losing a trial, simply with the time that he had served, those 18 years that he had served behind bars. And he said, no, I want to try this case. I am innocent, and I want to prove it in front of a jury. David, if you were his attorney, what would you do in response to that insistence?
Oh, I would go crazy. I mean, when you're offered something like that, you're risking everything in exchange for being a convicted felon, which you've already been in prison 18 years. And people are going to always cast that aspersion on you regardless. Any lawyer would urge their client, under the circumstances, to absolutely take that Alford plea and move on.
Absolutely. I mean, this is a man who stood by his principles, but as we know, even if you are innocent, the system doesn't always work perfectly. And so he really was facing a very, very real risk. Have you ever had a situation, David, where you had such a difference of opinion with your client, like a situation like this, that you said, listen, I can't represent you if you continue to go down this road? Is that something that you think these attorneys might have considered?
I think experienced lawyers, we take ourselves out of it after a while, and we realize we're not the ones on trial. And we give advice, and either they accept it or they don't. And if they don't, long as we're acting ethically with our professional responsibility, we're okay. And I think that's how lawyers get to after a certain point in their career, that they realize it's not about them, it's just about giving advice and advocacy.
Well, and the advice and advocacy that they gave came to bear interestingly in this trial. Let's throw to a clip of the first witness that we're going to show is one of the friends of the victims. And watch, as you watch this clip, think about what it must have been like to be the defendant sitting in that seat, knowing he gave up that opportunity, as David spoke about. And that's the testimony of one of the victim's friends who's talking about events that happened about 25 years ago, which is such an interesting thing, David, as we think about this case and the fact that the events at issue, the facts at issue, the recollections at issue all happened 25 years ago. How much of an impact do you think that that would have on this jury?
Honest will change, just because our perception and our memories and our minds may perceive things differently as time goes on. So what you would testify to 25 years ago and then today is not going to be the same, regardless if you're telling the truth or not. So it's definitely going to be a parallel difference that a jury might take notice of.
And don't you think that that would benefit the defense, obviously?
Right. Conflict in the evidence, as most standard jury instructions, is always a basis for the jury to find reasonable doubt. So if there's a conflict in the evidence, conflicts go to the side of the defense.
Yeah, I was once defending a case, and the events at issue had happened when I was in high school. And every time I had the opportunity to sort of throw that into the question, I did, to remind the jury, because don't you feel as though sometimes they're sitting there through the trial and it almost is like it just happened yesterday? You know, they forget that it was that long ago and that memories have faded and time has passed.
Right. I think juries, it's always a good reminder to let them know how much time has actually passed, especially as it goes to the believability of a witness. You can make a witness not a bad person, but unbelievable because their memory is not precise on what actually occurred most of the time years ago.
Right. The only thing that sort of counters that is the fact that they would have the transcript from the last trial to refer to and to prepare with. When you have these situations, David, anytime that you retry a case, you have these old transcripts. How much do you ask your witnesses to focus on recalling what it is they testified to in the past?
Oh, you have to make sure that they read their transcripts and to the best of their honest ability, mirror what they said in the past. It's very important. As police officers used to say when I was a prosecutor, it's not what happened, it's what's in the report.
Yes,
so,
exactly.
You know, the conflict in the evidence and impeaching a witness with a report or prior testimony is always very powerful.
Well, we're going to go back now to Jessy Hernandez's testimony as he continues. And Dave, when we come back in just a second, I'm going to ask you about this testimony. Returning to Jessy Hernandez and his testimony about what he remembers from that day. All right, David, we had some testimony there, and we need to go to a break in just a minute. But before we do, I want to ask you about objections, because it seemed to me that there was some testimony there that was almost objectionable. He was saying what the other people were thinking. Are there times as a trial lawyer that you forego the objection because it just doesn't make a huge difference in your strategy for the case?
It all depends. If it's something you can use later on cross-examination, you let it ride. But if it's speculative testimony like what this person was thinking or perceiving, that's generally highly objectionable, and it should be inadmissible.
Yeah, and we're going to go to a break, and we'll be talking more about this witness when we come back. So, David, we're continuing to watch Jessy Hernandez, and, you know, since time has passed since these events happened, his emotion has understandably sort of diminished. How does a lawyer on either side try to reinvigorate that emotion so that it can come across to the jury?
It's not easy. After 25 years, if it's vanished, it's vanished. And unfortunately, the jury might forget that it was 25 years ago, and it could penalize the witness, so to speak, for the lack of emotional state.
Yeah, I mean, I think it's really tough for the prosecutor to elicit that sympathy, that fear when no one's crying. You know, people have, while they haven't gotten over the death, certainly become accustomed to that loss. And so it makes it harder for the prosecutor. We're gonna go to another clip, and then when I come back, David, I want to talk to you about ways the prosecutor might have been able to overcome some of that, if it's even possible. But first, let's watch a little bit more of Jessy Hernandez and get a sense of what exactly it was he was trying to relay. So, David, here we have the testimony of Jessy Hernandez. He was there when these two gentlemen were shot. And the way that he's relaying it, it does get a little bit more emotional in that clip. In fact, when he's using the pointer, he says, "I'm sorry, my hands are shaking." Do you think that that is something that he was trying to use to relay the fact that he was nervous, almost as if it was something he was coached upon? Or do you think that that was the true emotion that he was feeling?
Probably the true emotion. It's hard to fake those kinds of things, and when you do fake them, they become patently obvious that it's an acting show, and so it seems that it was probably sincere. He's probably nervous for a multitude of reasons, and just having to be involved in a trial and subject to cross-examination is nerve-wracking alone.
Yeah, he's got a little bit of practice, right? Because he testified at least once before. But, you know, and a couple times, you're probably doing the same thing as I am. As she's asking questions, I'm sort of going, objection, objection. You know, there was some, as you mentioned before, there was some speculative testimony that was elicited from this witness about what other people were thinking when they picked up that water cover. And then I saw a little bit of leading there in the last clip. Why do you think the defense let that go?
You know, it's hard to say. Maybe they don't want to beat up on this particular witness because the witness doesn't offer as much evidence as that is required for a conviction. So why fiercely beat up a victim's friend and maybe not be liked by the jury by doing so? So just let it ride and knowing that it's not going to hurt you ultimately.
Yeah, I think that's a really good point about not beating up on this witness, because one of the things that I try to stress to the different people involved in my cases is that juries decide cases on facts, yes, but also on emotion. And as much as they want to leave their emotion, you know, we ask them to leave their emotion out of the jury deliberation room. Those are 12 humans who have emotions, have sympathy, and they definitely have a feeling for either side. We're going to come back and talk about that in just a minute, David. Right now, I want to go to a quick break. So, ladies and gentlemen, that was Juan Medina. He was one of the friends of the victims and was there that night. And David, if I can bring you back in here, it's so interesting to me. They're talking about even the roads and the traffic being different at the time that this event happened. It just underscores what we've been saying. This is so hard for both lawyers to try and establish something that's changed so much, don't you think?
Right. Cases are not like wine. You don't get better with age.
That's
they
right.
only get harder. So yeah, so it makes everything so difficult because even your own maps and your roads have changed and things change, and it's hard to recreate the crime scene.
Well, the other thing that I think is interesting is it's hard to imagine these two witnesses that we are just watching, Medina and before that I think it was Hernandez, how different they must look from when how they looked that first trial. Because we're talking about 25 years, so they've probably put some weight on. I mean, that first trial, they would have been just barely men and probably looking more like boys. What opportunities does the prosecutor have to try to bring back some of that emotion, or is it just lost?
It might just be lost, and that might not be the worst thing because a jury might think that that's normal under the circumstances. So hopefully there's crime scene photos and the like to sort of reenact the crime scene so people can put it in perspective of the time frame that we're dealing with. So I don't find the lack of emotion to be a terribly bad thing for the prosecutor. It would be great to have it, but it might look awkward if it was still there after all this time.
Good point. We're gonna continue to watch Juan Medina, and I do want to talk about the role that gangs played in this case when we come back, David. But right now, another clip from Juan Medina. So, ladies and gentlemen, that was Juan Medina. He was friends with the victims in this case. Those victims are Bobby England and Armando Laza. And that last bit of testimony, David, is what I wanted to talk to you about, because gang violence is a big part of this case, and there was definitely both sides have sort of woven that into the case. You know, throwing gang signs is something that we've seen in some of our other cases as well. Do you think that the fact that these no longer look like potential gang members had any impact on the jury?
I'm sure it did. It's got to be kind of weird to look at and now middle-aged men, right, and they were once quote-unquote gangsters. So but you know, you can chalk that up to youth and stupidity of being young. So it's definitely a factor, but you know, it's part of the factual circumstances as to why the actual homicide occurred.
Yeah, it's one of these cases where the jury really has to use a lot of imagination in all aspects of the case. They have to be able to imagine those streets looking a different way, going a different way. They have to be able to imagine this witness as a youth in a gang throwing gang signs or not. You know, it really calls upon the imagination of the jury. Does that change the way you pick a jury, David?
Well, it's interesting. So when you might have people in the jury that weren't even born.
That's right.
And so then you're putting things into perspective of nomenclature that occurred back in the 90s, and it won't make sense to them. It's like talking about the Vietnam era with me. I mean, it's just, well, I wasn't around. So so you probably want to pick an older jury so that they kind of understand the totality, and and a jury that's lived in that area of the city back in the 90s, so they understand how the city was back then versus how it is now.
Absolutely. I was thinking the exact same thing as I'm looking at this case. I'm thinking, there could be jurors there who were not even born when this happened, and that certainly changes perspective. When you go into jury selection, voir dire, you really have in mind sort of the types of jurors that you would want. If you had younger jurors, would that in and of itself be something that would sort of make you want to push them not on the jury if you were on the defense side?
No, I think the defense would want a younger juror because they might say it was so long ago. Let's move on, right? Yeah. Because in their lifespan, it was before they were born, so it was a very long time ago. Yeah, so I think the defense would want the younger jurors.
Yeah, we know it was 7 women and 5 men, but I'm not sure in the ages. David, we're going to go to a quick break, and then we're going to come back with more testimony in this case. We'll be right back. Well, ladies and gentlemen, that is the forensic investigator, Jeffrey Kelly. Less than compelling testimony, David. It's hard to make those types of witnesses, these experts, exciting for the jury. How do you think the prosecutor did in attempting to do so?
I'm not quite sure what the point he was trying to tie together between the casings and the actual projectile. It sounds like better questions for cross-examination by the defense. Yeah, unless it's leading to something that or a point that he needs to make or to get ahead of where the defense is on a particular issue. And
I think that's what we'll see in just a minute, and then you make a great point, because we're going to go to cross-examination in just a minute and see that might be getting in front of things. But let's talk a little bit about that, because that's something that we often do, right? Rather than letting the other side get the full effect of some testimony that might not be great for our side, you try and sort of take the sting out?
Absolutely. So you try to bring it soft landing, and so that when they bring it out, it's not like a I gotcha game or the prosecutor is hiding something. It's to maintain your credibility with the jury.
Yeah, you said the exact magic word. So many times I talk to young associates about credibility, because if you lose credibility with the jury, you are lost and your case is lost. But even little things that might otherwise hurt your case, if you can maintain credibility with the jury, sometimes you can actually explain them away in your closing. Don't you think that's true?
Absolutely. If they believe you, then you're 10 steps ahead. If they don't believe you, you're behind the 8 ball the whole entire trial.
Yeah, it's not only do they have to believe you, they have to believe your witnesses, they have to believe your case, but ultimately you as the lawyer are the one who's standing up there the most often. So to David's point, credibility is key. And we'll see now in this next clip how cross-examination sort of tried to make the same points. And so as David said, taking the sting out of some of that by asking it first and having it come out of your mouth might be helpful. So let's watch that cross-examination and we'll be right back. Ladies and gentlemen, that is one of the forensic experts in this case of Daniel Villegas. And David, let's talk a little bit about forensic experts in general, because in this day, we've talked a lot about this on the Law and Crime Network, in this day of watching SVU and all of those types of TV shows, juries really do expect to hear some strong DNA evidence, some strong evidence with regards to the guns and matching up. And when they don't hear that, do you think that it puts the prosecutor at a disadvantage?
Oh, absolutely. In the world of TV, it's the perception of the jury is really an unrealistic one. Fingerprints, DNA, CSI, cool little lamps that detect blood and things like that. And if they don't see it, and they think that there was a sloppy job by the police, and they can find reasonable doubt on that alone.
Yeah, we really hold our police to such a high standard now, because on these quick TV shows, we have the opportunity to sort of get everything tied up in 1 hour. Do you think that prosecutors are well served by explaining to the jury in their opening that that's not the way that it works?
Oh, I do. I always did it in my jury selection. I did it in my voir dire. I got ahead of that quickly. That this is the real world, and these are how our investigations are done, and it's not TV. That's something you got to get out very early on.
I love that you got that out in the voir dire. When you did that, David, would you ask jurors whether or not they would be able to overcome the bias that they might have developed by watching a lot of television and accept this case with the facts as they've been presented?
Yeah, I tie it in with whether they can follow the law, and the law doesn't require CSI level evidence. It just requires reasonable evidence beyond a reasonable doubt. So I tie it in very early.
And were the jurors honest with you about whether or not they could do that, do you think?
Yeah, I think it's strange because they're not realizing their own perceptions being challenged. But it's something you got to get out early.
Yeah, they don't realize that they have that bias because they have no reason to make that realization. Do some of them sort of light up at the idea that you've recognized this?
Correct, and so you get more real. You want to get more down to earth, more realistic juries, and it's helpful.
Great, David. We're going to go to a quick break, and we'll be right back to talk about this case a little bit further. So, ladies and gentlemen, as we cover this Daniel Villegas case, and we just saw the case of a mistrial, and the defendant claimed that the confession he had given had been coerced. So I want to talk to my guest. We have David Pietro, who's been with me since I came on here. He's a trial attorney, and now we have Judge Birmingham with us as well. Gentlemen, I want to talk to you about this idea of coerced confessions. This type of thing plays well to a jury, it seems. It certainly did in that case with the mistrial. It certainly did in this Villegas case. What do you think about that? How do you think that impacts a jury, this discussion of the possibility of a confession having been coerced? I'll start with you, Judge.
Well, thank you. It's good to be here. I think intuitively, jurors are a little bit skeptical that a confession could be coerced, but they will certainly consider the facts and circumstances. In the Villegas case, he was, I believe, 16 when he talked to the homicide detectives, and that age disparity is going to go a long way in convincing jurors that what he said was coerced. The use of leading questions by the detectives, that's also a red flag. The fact that Villegas gave a statement that was inconsistent with some of the evidence that was the physical evidence that formed the res gestae of the crime. Well, that's also raises a red flag. So they consider those circumstances of the statement. They also are going to consider the age, the mental acuity of the defendant, and in their analysis of whether or not a confession was coerced.
Yeah, and David, it can be a double-edged sword and a little bit dangerous to start throwing stones at police officers, can it?
It depends on your mix-up of the jury, what city you live in, and whether there's a good relationship with law enforcement or a bad relationship with law enforcement. I think Chicago is a big example of that right now. Baltimore was in the past. I think the judge is right. I think just saying that a confession is coerced in and of itself is not really believable. You have to have something to back it up. And in this case, the defendant believed that he needed to confess to go home. And that's something that a jury can reasonably, if the evidence presents itself that way, can believe in that. Or the mental acuity, as we see that sometimes people with below average intelligence can be coerced under duress to confess. So it really, you have to put a totality of circumstances to really get that kind of coercion argument in play in front of a jury.
Yeah, and in this case, it came into play in motions as well. So I'm glad we have a judge here to talk about that in just a minute. Right now, I want to throw, though, to the testimony of the medical examiner in this case. When we come back, we'll talk to Judge Birmingham and David about that testimony. Ladies and gentlemen, that's the medical examiner testifying in this case. And I want to bring back the judge and David Pietro and talk about something that is a little bit ridiculous when people hear it, but it's true. I make sure that you gentlemen agree with me. Are there times in your cases, David and Judge, where the jurors actually fall asleep? And the reason I ask that is because I've seen it happen, but never with a medical examiner. What's been your experience, Judge? Well,
the quickest way to put somebody asleep is to talk about DNA evidence.
That's right.
That's my opinion. The medical examiner, it's fascinating to me, and I think most people share it, just to figure out the way that the human body works, the fact that it is a machine, and the fact that there is an injury that so interferes with this machine that life can no longer be sustained. And so you've got the value of the medical examiner is usually the centerpiece of a lot of the fight in a case. I mean, the witnesses are going to say, I was this far away from, or when I saw this person shoot and they shot in this direction, they shot him in the front, they shot him in the back, they were running away, whatever the circumstance may be, and all of that better match up with what the medical examiner says. It is a good fertile ground for objective proof. It either was an entrance wound or it was not. It was either up and to the left or down and to the right. I mean, it's a good fertile ground, and I think jurors really buy off on that.
Yeah, that's a fabulous point, David, because as an attorney, you've got to really be listening to the nuances of every single thing that medical examiner says, because you need to point out, as the judge says, any little changes between that and what any of the witnesses have testified to, and jump on it for your close. Do you make sure that you sort of make a list of those?
Absolutely, and the medical examiner is going to come with a high level of credibility. It's sort of as a disinterested neutral party, a doctor who's looking at it from a medical scientific standpoint and not from a police law enforcement standpoint, even though they tend to lean towards the state prosecutors because they work together a lot on cases. So yeah, it could be boring, and in this case it might be a little boring because everybody it's not refuted that the victims died of a firearm. The bigger issue is, was it the shooter, the person that's sitting in the defendant's chair right now? So that's probably why it's not the most lackluster testimony.
Yeah, and one of the things that they do to sort of make that better, to your point, Judge, is the exciting part is the pictures. The pictures can often make the case more exciting, and especially pictures from the medical examiner. Judge, do you often see motions to preclude some of those pictures because they're just too gory?
Absolutely, and in every trial I think that I've had, either when I was trying cases as a prosecutor or now, of course, ruling on some of the admissibility of some of these pictures, the defense wants to make sure that there is no pictures, or as few as possible. The state tends to want to maybe try to evoke some emotion and some sympathy for the victim, so there's always a balance. You got to keep everything more probative than prejudicial, and you'll be just fine.
Yeah, and we're gonna go to a break, and then we're gonna come back and hear some more from the medical examiner and from the judge and David. So stay tuned. Ladies and gentlemen, welcome back to the Law and Crime Network. We are watching some replays of some clips of the trial of Daniel Villegas, who was accused of murdering two gentlemen. He was tried, it was a mistrial. He was tried again and he was convicted, served for 18 years. Then that conviction was overturned, and now this trial. You are seeing the testimony of his cousin, David Retrial, who is testifying to an alleged confession that the defendant made. I want to bring in my guests, Judge Birmingham and David Pietro, and talk to you guys about confessions, because we talked a little bit about this before, whether or not juries believe them or don't believe them, depending on whether or not the police allegedly coerced them. But we know in this case, Judge, that the other confessions were thrown out. Do you recognize every time that you make a ruling just how vital that ruling is to every case? Because in this case, it really, much of the prosecution's case was thrown out with that confession.
Well, yeah, I think that you have to consider the importance of a particular piece of evidence in the whole grand scheme of things. And obviously, a person who is confessing to the crime for which they are charged is a very important piece of evidence for the prosecutors, and you've got to consider that. When you're going to make a decision about something like that, you have to be very mindful of also the rule that says that basically the judge is not supposed to be a fact finder, whether something is believable or not. The judge is supposed to be there to be a gatekeeper, but really leave it up to the jurors to decide what the facts are. But if there's something that was given in violation of the law, well, then you got to keep that out. And that's what the judge decided in this case. Now, what I find is really interesting, and I want first David's opinion on this and then the judge again. In this case, the judge determined that that confession should be thrown out for legal reasons, as you said, Judge, not factual reasons, but because he's serving as a gatekeeper. Then, David, the prosecutors actually appealed that decision during the case. Don't you worry, because we know judges hate to be appealed and hate to be overturned. Don't you worry, David, that you're going to make the judge angry when you file an appeal while the case is about to go?
Well, since I'm married to a judge, I know how that goes. So yeah, I think as lawyers, though, we have to do our job, and it's not personal. Just like when the judge rules against us, it's supposed to not be personal. You have to be an advocate for your side of the case, and that's very important. And judges, yeah, they say they don't get upset when they get reversed, but I know that to be quite the contrary. But as a lawyer, as long as you act professionally and you do your job, I think in the end, no good judge would ever hold that against you. Yeah, I mean, we ultimately, to your point, our job is to be advocates and strong advocates for our clients. But Judge, that is the sort of the measuring stick for you judges. Is it something that's important to you, or do you just decide each case and then just let it go behind you? I'm trying to peek under the robe here. You make the decision as best you can with all of the available
We may have lost the judge there. In the meantime, though, I think that one of the things the judge is going to say is what we've been saying over and over again. You make these decisions, the judges do, based on the evidence that they have, just like the juries do. I think we have the judge back, and he can say it much better than I could on his behalf. Go ahead, Judge.
Well, I was just going to say that, it seems to me, I always consider myself to be sort of in the trenches shooting with a shotgun. Those justices and the judges in the appellate courts have a lot more time and a lot more resources to make these decisions. And, you just have to do the best that you can, relying on the lawyers. Nobody holds it against anybody else. You try to give the jurors as much information as is lawfully allowed and let the jurors make the decisions on all these cases.
Absolutely. Okay, guys, we're going to go to a break. When we come back, we will continue with this very compelling case. So, Judge Birmingham, that was some heated cross-examination of the cousin about that confession. How effective do you think the cross-examination was, given the amount of time that has passed? And then we're going to go to the prosecutor's closing.
Well, what they've got to work with is a signed written statement that goes all the way back, 25 years. And it's interesting to me, what strikes me about it, when you say that somebody confessed something 25 years ago, what seems to be the issue in this case is not that confession was made. It is whether or not he meant it. Right. It's obvious that this witness does not like the prosecutor, is not comfortable testifying. There's a lot of tension there. And I don't know how that's going to play for the jurors. The jurors look at as much at the body language and the way that they're speaking as much as they do the words that are being spoken. So it'll be interesting. That
is the truth. Now we're going to see how the prosecutor uses all the testimony that we've been watching, and we're going to go to the prosecution's closing right now. All right, ladies and gentlemen, that was the closing argument on the defense's side. I want to bring the judge back in to talk a little bit about this closing argument and the verdict that is yet to come. Judge, the way that defense attorney handled the closing, step by step, witness by witness, that's a really effective way to sort of go through everything the jury has heard up until that point, isn't it?
It is. He started out with the very first witness, walking them through. I think he comes across as very credible. He comes across as very methodical, pointing out kind of like, this is the best the state has to offer, and then sort of pointing holes at all of the things that help him out in the case and in the testimony. So he's going through very methodically, and you're going to, I think, get to the end and hear him say, basically, this is not nearly enough to convict somebody of capital murder, even putting the best spin on it.
Yeah, and he had an enormous amount of stress on him, given the fact that his client had rejected a plea deal that would have had him walking. Lawyers are human too. Do you think that was sort of hanging over his head in a way that made it an even more difficult, more challenging, more emotional argument for him?
It was a beautiful contrast I saw in his closing argument. He actually stood up and said, this is something that is very easy for me, because I think what he was saying is that it's so simple, because all I have to do is tell you all to follow the law, and the law will guide you to a not guilty verdict. Now, that's him on the outside. On the inside, he's got to feel a tremendous amount of pressure, just like I'm sure the prosecutors felt a tremendous amount of pressure from the public. And after all, this case reached into and guided and was an issue for the local DA race there in El Paso.
Yeah. So we're going to now, ladies and gentlemen, show you the verdict in this case. And remember, this is a gentleman who has spent 18 years in jail, now waiting to see whether or not his bet that he took, that he could prove his innocence, would come to pass. So watch the verdict in this case. Whew, man, that is something to see. Judge, that gives me goosebumps, and I wasn't even in the courtroom, and it's a replay. How often do you see that kind of response to a verdict?
Oh, it's obviously a very emotional time for everybody involved, but I mean, that was a catharsis. That was 20 years in the making. I mean, he had been in prison. You got to remember, too, that once you're convicted, appellate courts don't like to overturn verdicts. And he got that verdict overturned, and every step along the way, he was waiting for this very dramatic moment. You obviously see his family in the background. It was something to behold, a very dramatic moment that was 20 years in the making.
Yeah, as I was walking here today, I was thinking about it being Thanksgiving tomorrow, and for 18 years, he didn't have Thanksgiving with his family. He didn't see the sun come up. He didn't see the moon go down. And now knowing that he has the rest of his life without this hanging over his head, so much to be thankful for here. I have to say, it seems to me, as we look at the defense counsel there holding on to him, there's a lot of emotion for counsel there, too. I know you were a prosecutor. I'm a practicing trial attorney. We lawyers can't help but feel emotional, especially at verdict time, right?
Oh, absolutely. You saw the very fine defense attorney. I think he closed his eyes a little bit, said a little prayer right as the judge was reading the verdict, and obviously he put a lot of work into the case and did an excellent job. It is hard to beat a murder case, and he did exactly that.
Yeah, it was an amazing case, and even more amazing, here at Law and Crime, they had the opportunity to interview the defendant. So we're going to throw to a clip of that for you guys right now. What a story, ladies and gentlemen. Judge, I know you're staying here with Aaron for the daily debrief, but do you have any last thoughts on this case that we recapped today before I sign off for the day?
I think my final thought is keep fighting. It's just an impressive 2-decade-long fight, and all in the interest of serving justice. And I would also say that, that he is not guilty, and we know that those 2 boys were murdered, means that we need to figure out who did the killing. And I'm hopeful that the investigators and prosecutors will continue to look into that case.
That's a really good point, Judge, because sometimes in an emotional case like this, we start to sort of relate to the defendant and don't recognize that there are victims here, and the families of the victims certainly need to have some justice. Ladies and gentlemen, it's been my pleasure to bring this case to you. Judge, I know you're sticking around with Aaron, so I will see you later. And we will, in just a minute, be back with the daily debrief. Have a wonderful Thanksgiving, and I will be back again sometime soon.